All right, welcome to another episode of FUELcast TV. I'm your host, Ian Murphy. FUELcast TV is where we talk about things that are related to freedom, unity, entertainment, and liberty. This week's episode is a bit of an update on the Iron Pigs lawsuit, a declaratory action against the Health Department of Northwest Michigan. We filed this case back August 10th of this year. There has been a little bit of back and forth, but this is a quick update and just to kind of remind everybody exactly what it is we're doing. We're not suing for money damages. We're suing for declaratory statements to be made from Judge Hunter about a couple of statutes that he pointed out have some fatal flaws, as did the statute that we had him rule unconstitutional back in January of 2022. So here we are again, basically going after 5 additional statutes and introducing a new argument. We did a podcast about this before, kind of going over the vesting clauses, so I won't recap that entire thing here, but I will bring it up. We're going to move over to the whiteboard here in just a quick moment and go over just a couple of quick things to give everybody a broad look, kind of a 3,000-foot view of exactly what it is that we're trying to do. We're certainly not trying to relitigate anything from COVID. We're basically looking at the unconstitutionality of some very broad language that is in these other statutes that were used against the Iron Pig and myself. But more so, it is power that the state government and the local government specifically still retain. And this is what we're looking at Judge Hunter, at having him look at these statutes and basically declare the same thing as he did in the other ones, is that there's a non-delegation violation here, which simply just means that the legislature gave too much power to the health department back in 1976 or 1978, whenever these laws were passed. 1978. The legislature, maybe while well-intended, inadvertently gave too much law writing ability to an executive branch agency. That has been our argument from day one. That is what Judge Hunter upheld, on top of and using the in re-certified questions case from October of 2020 that said that the Emergency Powers of the Governor Act also had the same flaw, saying that there weren't sufficient guardrails in place, and Governor Whitmer also violated the Emergency Management Act, which requires a renewal or hearings at least to justify another week or 28 days or whatever. So 28-day tranches in the Emergency Management Act is what right now, as it stands, allows the EMA to be constitutional, and the Emergency Powers of the Governor Act wasn't. And also now MCL 333.2253 has also been ruled unconstitutional in 46th District Court and by a 3-panel judge in the Court of Appeals. That is now on its way to the Michigan Supreme Court, but it's going to be awfully difficult for the Supremes here in Michigan to overrule themselves within basically a 4-year span. We expect that to hit their docket probably sometime early or mid next year. So what I want to do real quick is switch cameras, switch over here. We're going to go to the whiteboard. I'm going to break down a couple of things real quick just to kind of easily explain, as we always like to say, to the guy on the other side of the bar, so people understand exactly what it is that we're doing. We're not trying to fight COVID mandates. We're simply seeking clarification on broad language that was used, similar to the health director may limit the gathering of people for any purpose and establish procedures. Those words were used to damage and destroy Michigan's economy, businesses, individual livelihoods. That 2253 did more damage than the Emergency Powers of the Governor Act did, because they released so many emergency orders that went beyond what the Emergency Powers of the Governor Act was implementing, the executive orders, as everybody remembers. So give me just a quick minute here, and I'm going to switch over cameras. All right, thanks for sticking with us. And to switch over to the whiteboard here, I want to give a quick little breakdown. It's always important to go back where we started to where we are now. Coming into November, this is the time of the year that new emergency order, they kind of switched over from executive orders in October 2020 to the emergency orders issued by the health department. That was because of an October, I think, 4th, 2020 ruling from the Michigan Supreme Court, ruling the Emergency Powers of the Governor Act, the executive orders that had been issued since March, were unconstitutional. The intelligible principles that were contained within the EPGA, which is the language that guides that law, they basically said the words reasonable and necessary weren't compelling enough to be able to sustain the constitutional muster, basically, is what they said. And it's much better language than that. But October of 2020, EPGA was ruled unconstitutional. 2 or 3 days later, I think that was maybe a Thursday, Friday, come Monday morning, October 2020, the government switches over to 2253, which they had been using all along. But what they did was they used 2253 to issue the executive orders, just now under emergency orders given out by the director, the state health director of the health department. So our case, through everything that we went through, had the state health director's authority removed as unconstitutional. That's MCL 333.2253. We always are talking about that one. That one was also ruled unconstitutional, basically on the same guidelines as the EPGA, as a non-delegation violation. Now, before I go any further, I want to read one quick thing, and I've said it before and I'll say it again, but James Madison explains it very, very succinctly. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. So that's what we're constantly talking about, is these executive branch agencies that have all of this power, lawmaking, rulemaking power, and the power to enforce, right? We always go back to our handy dandy little board right here that shows the judicial branch that interprets the laws after the legislature passes them. Then the executive branch enforces the law, right? We always talk about speed limits. The speed limit on I-75 up here in northern Michigan is 75. The legislature passed that law. The judicial has interpreted that. The executive branch, state police, are now enforcing that. Tyranny, as explained by James Madison, would be the executive branch over here decides that they're going to change the speed limit on I-75 without including the legislature to pass the law. Our elected officials, this is the check and balance right here, our elected officials write the law, interpreted by the judicial, and then executed by the executive branch. The EPGA and MCL 3332253 intertwined the two of these, basically saying that the executive branch had too much authority to write the law and to enforce the law. That's what this entire thing is about, is the broad power, the available use of power that still remains to this day. So, Emergency Powers of the Governor Act from 1945, that was a law that was mainly written for rioting, right? So this law had been around for a long, long time. They dusted it off in early 2020, used it all the way up until October. Michigan Supreme Court ruled it unconstitutional as a non-delegation violation, meaning the legislature, while maybe well-intended, gave too much power to the executive branch. The executive branch took that power, wrote their own laws, and enforced their own laws, thus creating tyranny, right? EPGA's unconstitutional. So then we come to October 2020, right? They knocked down the EPGA statute. Along comes Robert Gordon and the health department, utilizing 2253 among other statutes. But the statewide statute is 2253. And in this statute, the language that they use, again, this is what I'm always preaching about, the use of language and how it gets meandered over time. These people took, in October of 2020, the language, the health director may prohibit the gathering of people for any purpose and may establish procedures. That one sentence right there allowed the state health director, Bob Gordon, and Elizabeth Hertel after him to create laws such as sign-in sheets, social distancing, masking, curfews. You're only allowed 12 people in your home for Thanksgiving. A number of crazy, crazy things that the executive branch was given the privilege and the authority to write and execute these rules, these laws. They did it to Marlena's Bistro and put her in jail. They threatened me with jail at 10:30 at night. This is what this is all about. Judge Hunter ruled this unconstitutional January 2020. Then over a year later, Court of Appeals also rules this law unconstitutional. Again, the same reasoning, non-delegation violation, right? The legislature inadvertently gave too much lawmaking, law-writing ability to the executive branch. These are people that are not elected. They're appointed, right? Liz Hertel and Bob Gordon were appointed by the chief executive, Gretchen Whitmer. So that's what those two things have in common, right? A, they're unconstitutional, and B, confers unlimited authority to unelected bureaucrats. This is what is happening at the federal level and at the state level. We've seen numerous U.S. Supreme Court cases in the last couple of years saying the exact same thing, that these administrative agencies have gained too much power. The EPA is a great example of it, right? There was a case that was just decided last summer, basically citing the EPA as having no constitutional authority to write and enforce laws. This was around EPA greenhouse gas emissions, was what this that particular case was revolving around. So, Judge Hunter rules in favor of Iron Pig January 2022. June of 2023, Court of Appeals and the T&V Associates case gets ruled unconstitutional after it works its way through the Court of Claims. Michigan Department of Health and Human Services gave up their appeal to the Court of Appeals and to the Michigan Supreme Court because they thought they had a win with the T&V Associates ruling, which then got overturned by the higher court in the Court of Appeals. That is moving up to the Michigan Supreme Court, And again, the Michigan Supreme Court has their own precedents that they have to follow from October of 2020 with the EPGA ruling as unconstitutional and a non-delegation violation. So the next step in the process is looking at that ruling, the Iron Pig ruling from Judge Hunter. He points out that there are a couple other statutes, particularly MCL 333.2453. 2453 sounds very, very similar to 2253. Again, there's a couple of differences. 2453 versus 2253. The only difference in the wording is they remove state health director as being the authoritative figure with local health director. Again, the local health director is a hired position. Now, it is hired by a board of health who we then elect. County commissioners populate that board of health. Board of health then hires an administrator. That unelected official then can make decisions such as putting masks on, social distancing, requiring certain businesses to close at a certain time. And let's not forget, this particular 2453 was also used when putting masks on school children at the end of 2020, which then in turn created a lawsuit called Let Them Breathe that challenged a number of other statutes in the school code as well as this one as well. So 2453 is on the list to take away the local health director's authority that is identical to the state health director's authority, which has already now twice been ruled unconstitutional. Boom. Then we move to 2451, also contained within the public health code. The language that we have issue with in this one, again, it's all about the language and the words and then how they can be interpreted or twisted, in my opinion. The verbiage in this one, a condition which could reasonably be expected to cause death and disease. Reasonably is not a definitive term, right? When you look at legislation for, say, again, speed limits, there is a very specific speed that you cannot go over before a law is broken. A condition which could reasonably be expected to cause death and disease. By the way, the conditions in my restaurant were reasonably expected to cause death and disease while the Iron Pig was still open. Now, it is on record, admitted by the health department, that there was never a single case of COVID or even contact tracing in the Iron Pig the entirety of our case. They had to admit this. So we were charged with a condition which could reasonably be expected to cause death and disease. There never was such a thing, but they felt that the word reasonably could be used at such a broad, wide term, they could use it against the Iron Pig. So let's move to 2455, right? Another one. This is number 3 in the Public Health Code of 1978. The language we take umbrage with here, quote, the health officer reasonably believes. Local health officer. This is a unelected person that can create a law and then has the power to enforce that law. A local health director. Health officer, not even a director. Here's a crazy case. Never hasn't happened that I know of, but let's just say somebody doesn't agree with my political point of view and happens to be a local health officer that happens to come in here and do my biannual inspection. This person could find something that they reasonably believe could be of harm, right? In combination with a local health director may establish procedures, right? We start taking all of these things together, reasonable and necessary. Like, you start putting all these things in combination together, You get unelected people that have levers of authority at their grasp. It's that simple. This is what we're talking about, unelected health officials. Let's go to the next one, 5201. 333.5201. The health officer reasonably believes to harbor an infection. Again, this was something that was used against the Iron Pig, even though there was never any disease at the Iron Pig, simply because we stayed open against the mandates. They felt that we reasonably were harboring an infection, when in fact there was never infection or disease on the premises that the health department and the liquor commission, by the way, also happens to permit. 5201. Here's 5203. We're going down the list. 5203, the language requires cooperation if, quote, the health officer reasonably believes an individual has an infection without further evidence. Again, this is a health officer, not even the director. The health officer can unilaterally make a determination that I, as the license holder, am required to cooperate. Whatever that means, required to cooperate. My assumption would mean I have to close, I have to remediate, I have to do something, right? Requires cooperation if the health officer, again, reasonably believes an individual has an infection without further evidence. That's astonishing to me. Again, this is somebody that could harbor some kind of ill will towards me or another licensee that can take this language and extrapolate it out to whatever they deem necessary. So, it's worth pointing out, I mentioned the Let Them Breathe school mask mandate case that is still ongoing, by the way. Earlier this summer, they had a big win in court. There was an issue of mootness because the mandates had been rescinded. So at least a dozen of these mask mandate cases were dropped within a week to a week and a half of Judge Hunter's ruling with the Iron Pig of unconstitutional. 12 of 15 cases that I know of were automatically killed, removed, moot, done, don't belong in the court, simply based on the fact that the health department, whether the state or in this particular case, the local schools and the local health departments rescinded the mask mandates as these lawsuits were being implemented and the Iron Pig win became known. The Iron Pig win destroys any chance that these cases have of moving forward, specifically because of non-delegation violations all over the place in the health code and the school code. School code 380.11a. So this is Comstock, Let Them Breathe, and I believe there's a case in Kalamazoo. A superintendent. Superintendents aren't elected. They're hired. They're appointed. By whom? School board members. The school board members are elected. They then get together and hire an administrator. The power rests with the unelected administrator. The language that they used in order to put masks on our school kids here at Gaylord Community Schools, hence the Let Them Breathe lawsuit, they simply hang their hats on the two words safety and welfare. Now, people know, especially now, masking on students, social distance learning has had tremendous dire effects on our students, especially here in Michigan. We had some of the longest lockdowns, some of the worst lockdowns, and the longest and worst recovery. This is part of it. They believed that they were protecting our students, your students' safety and welfare by requiring masking and requiring distance learning. Now, what really angered parents in our school district was the superintendent and the parents had already had a plan of action. They had choice. You could allow your students to come in person, or you could allow them to distance learn. The health department stepped in at the last moment, days before school was supposed to start in August, and flipped the script and said, masking is required. No longer a choice, it's required. A group of parents got together, sued the school and the health department of Northwest Michigan for exactly this, and they're looking at having 380.11a ruled as unconstitutional as well, because safety and welfare does not provide any intelligible principle for a judge or for a lawmaker or for somebody to take and extrapolate exactly what that means. Safety and welfare is so ambiguous. Limiting the gathering of people for any purpose is so ambiguous. All of this language is wildly ambiguous and allows people in positions of power, whether elected or not, mostly unelected, are taking this language and extrapolating it to things that have dire consequences. What's even worse is the majority of these people are exempt from any of the consequences of these actions. We've seen several administrators, locally and statewide, get large payouts after leaving their office. State Health Director Bob Gordon got a gigantic payout. Lisa Peacock, our local health director, who was ousted because particularly of this controversy, was given a huge payout. It was so difficult to get her removed because she has a contract. And so this is another thing that is being adjudicated out of, I believe, the Ottawa County area with their health department, and trying to remove health director or interim health director Hambley down there. We're watching that case because, again, it has implications. When you have people that are unelected making such big decisions that have wide impact, we need to be able to recall, we need to be able to fire, we need to be able to replace these people in a proper way. Now, there are people taking issue with the proper way that it's being done in Ottawa, and we're going to see how that case ends up coming out with their health director and the Ottawa Impact folks down there. That's been a very interesting case to see unfold down there, and we don't have much time to talk about that. So, the other thing that our new lawsuit against the Health Department of Northwest Michigan also introduces is what's called the vesting clause argument. In Michigan's Constitution, in Articles 4, 5, and 6, they very specifically say exactly what each branch is allowed to do. We talked about it briefly before in our handy-dandy little board here. Each branch has a very specific and enumerated duty. The legislature, again, writes the laws. We elect those representatives based on our electoral system. They write laws, they pass laws. It then gets shot over to the executive to ultimately be signed off and passed into law. If there is any kind of interpretation for that law that comes down, a challenge, so to speak, the judicial branch, an equal but separate branch, then takes and interprets that. We've seen some real issues with this judicial branch, mainly in the administrative law category, where all of those judges are appointed. There seems to be a very incestuous relationship in the administrative law area. Again, the administrative branch has grown so large that this administrative law branch really isn't in the judicial branch. It's contained over here within the executive branch. We knew this because all of our hearings were all under the administrative law branch. There is a portion of the Administrative Procedures Act that allowed us to finally, once we lost our way to the top, the Administrative Procedures Act allowed us to question the constitutionality of the health law in the judicial branch, completely separate from the legislature and the executive. So the vesting clauses argument, as we call it, looks at 4, 5, and 6, Articles 4, 5, and 6. In each one, they use the words vest. The powers are vested in the legislature to write the law. Paraphrasing. Power is vested in the judicial branch to interpret. Power is vested in the executive branch to execute the laws. Nowhere in those statutes, in those articles, does it say anything about divesting, right? So when we go all the way back to INRI certified questions and the overturning of the EPGA and the executive orders, and when those judges use the terms non-delegation violation, they're actually incorrect. Non-delegation is a concept that says in some instances there is an allowable divestiture of some of the duties or the powers of the legislature or one branch to the other. Michigan's Constitution actually says the exact opposite. It says, in no way can you give one of the other separate but equal branches any of your vested responsibilities. It says very clearly, it vests in that branch. It does not say, again, I'm going to repeat it, that you can divest any of those enumerated powers. You simply cannot. So the idea of a non-delegation violation is actually completely inaccurate. Even though the EPGA won on it, the Iron Pig won on it, we take it one step further and say there is actually no such thing as a permissible delegation of authority. We are introducing this argument for a couple of reasons. One, to go even further beyond the non-delegation argument that was made by the Michigan Supreme Court in October 2020, the ruling from Judge Hunter in January 2022, and the Court of Appeals in June of 2023. All are using non-delegation. While they are correct, they are not wholly correct. What we seek is to introduce this argument simply saying executive branch cannot write any law, any rule. It has to come from the legislature. It has to be interpreted by the judicial branch. The legislature cannot interpret their own law, right? It seems a little bit redundant because that's what they're supposed to do in their process when writing the law and then it eventually getting to the governor's desk. No way can they or are they allowed to exempt themselves and allow another branch, in this case an executive branch, to come in and write its own law and enforce its own law. It is so extremely simple. Essentially what it does is, if you were to take this chart right here, it creates an impenetrable wall between each of the branches. So you cannot cross. You cannot give any of that writing ability over to the executive branch for them to then enforce. You simply cannot do it. That is what we're stating. And the Michigan Constitution is very, very clear when it comes to this. Articles 4, 5, and 6. Power cannot be divested. It is actually this simple right here. This argument has very wide implications, not just for our case as it relates to the health department, but it also relates to the Liquor Commission, Michigan Department of Civil Rights, nearly every MIOSHA, nearly every branch. Eagle is going to be one that you're going to need to pay attention to with all the clean energy bills and stuff that's being thrown around right now. The EPA ruling from last year is going to have some big effect on this as well. This is how we rein in big government, as a lot of people like to call it. I'm a libertarian. I'm a limited government kind of person. The administrative branch, the fourth branch of government, as we like to call it, the administrative agencies, have gained so much power. The administrative law apparatus has so much power This is how you start to remove and take away that power and give it back to we, the people. When you read Michigan's Constitution, it begins, we, the people, not we, the government, or they, the governors or government. It's we, the people. We're the ones that empower our legislature. We are the epicenter of all of this, not the governor, not the state health director, none of these executive branch directors. We, the people, we hold the power on all of this stuff. So this is why it's wildly important for people to pay attention to local elections. It's wildly important to pay attention to judicial elections, especially. So many of these challenges are going to come around. Like I said, with clean energy legislation coming through, so much of that is going to have to be questioned. It's going to have to be asked to be interpreted by the judicial branch. All of these things are going to fall under any of this stuff in Articles 4, 5, and 6 that simply say there is no such thing as a divestiture. There is no such thing as a non-delegation violation because you simply cannot delegate any of your authority. It is quite simple. So, what is happening with our case now? We've briefed, they've reply briefed, and it was basically nothing, nonsense. They then questioned whether or not Judge Hunter should be the proper judge on our case. Now, what's interesting about this is it specifically has to go back to Judge Hunter by court rule. There is a thing called judge shopping, and it happens on either side in a lot of cases. There may be a favorable judge that somebody wants to try and funnel a case to. This prevents that. This court rule prevents that. It automatically has to go back to Judge Hunter. The burden of proof to overcome for a judge to recuse himself is extraordinary in a case like this. Judge Hunter and I would have to be like best friends or golfing buddies or canoe partners or something like that in order for him to have such an extreme bias. The other thing is he would have to be recusing himself. So it's almost a little bit of a slap in the face, if you will, for them to even suggest that. And it also kind of, to me, suggests that they don't know what the hell they're doing. The other thing that they have also asked for, I previously mentioned the T&V Associates case, which is on appeal by the health department to the Michigan Supreme Court. The lawyers for the health department know this. They have requested a stay of our case until the T&V case gets adjudicated through the Michigan Supreme Court, and God knows how long that could take. And the interesting thing is, if I were the one asking for those concessions, do you think for 1 minute that the state would ever capitulate to such a request? Or I should say, it's not so much the state, it's the local health department's council that is looking at this. But we know Dana Nessel's office, the Attorney General's office, has seen this document because it has such implications. There is the possibility that the Health Department of Northwest Michigan just gives this case up. I don't believe that there's any way that they will do that or that they could do that, again, because of the precedents that it would set. And it is only for our 4-county area. Our health department covers 4 counties up here in northern Michigan. When we win, it wouldn't have statewide implications. These are the local statutes. We had the state statute knocked down and then affirmed by the Court of Appeals. These are local statutes. So that's what we're looking to have done, is have these local statutes create the precedent and then allow other folks to go out and challenge in other jurisdictions as well. So as of today, what we have received is a pre-trial hearing notice. It will be via Zoom. We will put, I believe Judge Hunter has a YouTube channel for his online courtroom via Zoom. We'll publish that link for everybody to tune in. I don't expect it to be very entertaining by any means, but it is another step in the process. And it will be interesting to see what kind of argument they're going to come up with. The other thing that they have a new attorney. Their attorney was in Petoskey. They're now have been moved and based out of the Traverse City area, so they are semi-local. But it's going to be interesting to see what arguments they're going to put forth. They don't have very many good arguments. We've seen similar arguments trying to be made with the T&V Associates case. And obviously, we've seen several arguments being made out of our administrative law hearing cases, our hearings, I should say. So the saga continues coming into November, December, January, when they were coming after me, trying to shut me down, bringing the full force of the government after a little restaurant owner in northern Michigan. So we're still here. We're still fighting. We're still fighting for our right to run our business the way we choose. We're fighting for your right to live your life and make your health decisions on your own. And that's simply all we did for our employees and for our customers during 2020 and 2021 was allow adults to make their own decisions based on their own health criteria. We simply believe there shouldn't be a situation where an unelected government official comes in and makes decisions specifically that are unconstitutional and violating the vesting clauses of the Michigan Constitution. So, thank you for keeping up with all of this. Thank you for watching our little whiteboard session here. I will update everybody as soon as we get more information. December 5th, right now, is our pretrial hearing date. Again, I'll pump out any information and the link for the YouTube room for that. Thank you for staying with us. Thank you for the support. If you have questions, if you have comments, drop them. Leave them in the comments section here on YouTube, Rumble. We're all over the place. Spotify, iHeartRadio, any of those other places. Check out FUELcasttv.com. Become a member. Become a Mug Club member. All of these different things help support exactly what it is that we're doing and that we're fighting for. And we appreciate you guys always having our back and tuning in. Thanks. We'll talk to you soon.